This might look like a simple traffic ticket at first glance, but don't blink because this courtroom exchange turns into a surprisingly revealing clash between personal logic and the rule of law. We're in a Michigan courtroom for a civil infraction trial involving Cole Aaron, a driver cited for running a red light. No jail time, no criminal record, just a $120 fine and 2 points on a license. Sounds minor, right? But here's where it gets interesting. The defendant isn't denying the facts. He admits he went through the red light. His argument is philosophical. He believes traffic laws should account for judgment, context, and what he calls a citizen's good. The judge, meanwhile, is focused on structure, consistency, and the idea that laws don't bend just because someone felt it was safe. This case becomes less about traffic safety and more about how courts deal with people who challenge the system itself. Watch closely how the judge explains civil infractions, burden of proof, and why personal reasoning doesn't override written law. And ask yourself early on, should common sense ever outrank a traffic signal?
Wishes for the hearing. We're prepared to move forward with the hearing.
Is that what you wish, Mr. Summey?
I would just would like to see if there's any options as far as me getting a fine and not having to get the points on my license and stuff like that, because I wasn't expecting for me to be broadly punished for this citation, because if I had not stopped at the red light and I had just gone through it and almost hit somebody, I'm getting the same charge and the same amount of points, and there's no degree to it like speeding or anything like that. So,
Well, the traffic code, the Michigan Motor Vehicle Code, has a schedule of crimes and civil infractions, and there are points assigned to each offense and fines by fee schedule. This is a civil infraction. It's not a crime. You don't get convicted of guilty of a civil infraction. You're found responsible or not responsible. You can't go to jail for a civil infraction. And the burden of proof is lower. In a criminal case, you have to prove guilt beyond a reasonable doubt. In a civil infraction case, you only have to prove guilt beyond a preponderance.
This is an important teaching moment from the bench, and honestly, the judge does a solid job breaking it down. A civil infraction is not a crime. You're not found guilty, you're found responsible. There's no jail time, no criminal conviction, and the burden of proof is significantly lower, just over 50%. That's it. The judge also explains something many people don't realize. Once you've paid the bond, the court can apply it directly to the fine and close the case. The officer is present on overtime, and the city is ready to proceed. At this point, the defendant has a choice: accept the points and move on, or go to trial and risk exactly the same outcome. This is where the tension starts building. Law is clear, the consequences are modest, but the defendant feels the system itself is unfair, and that disconnect between how the law works and how people feel it should work is about to become the heart of this entire hearing.
Of guilty of a civil infraction, you're found responsible or not responsible. You can't go to jail for a civil infraction. And the burden of proof is lower. In a criminal case, you have to prove guilt beyond a reasonable doubt. In a civil infraction case, you only have to prove guilt beyond a preponderance, which is 51% to 49%. So it's a lower burden of proof. It's not a crime. You can't go to jail. You've already paid the fine. The officer's here on overtime. He came in once before to testify. He's here again. Mr. Reed, any response to that?
I mean, we're here for the hearing. The charge is the charge.
Yes, so the city's not willing at this point to alter it. With that in mind, you just want to pay the $120 fine, and you wish to have a hearing on this.
if I pay the fine, am I gonna get the points and stuff
Yeah,
like
you're
that?
gonna get 2 points.
Well, then, yes, I'd like to continue this.
All right.
I mean, if people can sit in jail and fight their case and have it get dumbed down, all because that the courts don't want to go to trial and they'll just give them a better deal. I don't understand how I can't get at least a warning on this,
And here it is. The moment that quietly sinks the defense, Mr. Samo openly admits that he stopped at the red light and then chose to go anyway because he believed no traffic was coming. He doesn't deny understanding the law. He just believes his judgment should override it. From a legal standpoint, that's devastating. Courts don't operate on vibes, instincts, or personal assessments of safety. They operate on statutes. And once the defendant confirms he knew the light was red and proceeded anyway, the legal analysis becomes very short. The judge even repeats it plainly. You don't go until it's green. There's no citizens good to go. This exchange highlights a bigger issue when someone believes compliance is optional if they disagree with the rule. That's not how traffic law works, and it's definitely not how courtrooms work. So here's the question for viewers. If everyone decided when rules applied based on personal judgment, what would intersections look like?
All right, so you're not going to lose your driver's license. You're going to get 2 points on your driving record. You've already paid the $120 fine, so I'll use your bond to pay your fine. The case will be done. But if you wish to have a hearing, the city's ready to go forward.
Yes, I would like a hearing if the
All right, well
charges
then
are
let's
gonna
just go
be
through it.
changed.
Okay. My first witness is Cole Summey.
All right, well, let's have Mr. Ware and Mr. Summey both raise their right hand. Mr. Summey, do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes, Your Honor.
All right, in a civil infraction, because it's not a crime, you don't have the right not to testify. So the city is calling you as a witness. So would you come up and have a seat in the witness box? Your name is Cole Aaron Summey.
Yes, Your Honor.
All right, very good. Mr. Reed?
Thank you. Does court need the spelling of his name or is it?
No,
good?
we got it. Summey.
And Mr. Summey, you were operating a motor vehicle within the city of Sturgis on April 27th, 2025, correct?
Mhm.
Is that a yes or no?
Yes,
And you were on Nottawa Road at or near Chicago, meaning US 12, the main intersection there at Nottawa Road at around 11:36 in the morning. Is that correct?
yes.
And at that time, you came to the red light that was facing your direction.
At this point, the judge's frustration is unmistakable, and honestly, it's earned. The court has explained the law, clarified the points, outlined the consequences, and given the defendant every opportunity to be heard. Instead of accepting responsibility, the argument shifts toward constitutionality, automation, and resentment toward traffic lights themselves. The judge shuts that down quickly. The Constitution doesn't guarantee a right to ignore traffic signals, and courts aren't forums for redesigning municipal infrastructure. What really tips the scale here is the wasted time, multiple hearings, officer overtime, and a trial that ultimately hinges on the defendant's own admission. This is a reminder that exercising your right to a hearing doesn't mean freedom from accountability. Courts respect challenges grounded in evidence, not personal philosophy. And when a judge says, "You've wasted my time," that's not just irritation, it's a conclusion that the legal process was misused.
I feel like that would just be going against what I know is right.
No other questions, people rest.
All right, Mr. Summey, is there anything else you'd like to tell me?
I mean, I just hurt my feelings to think that just because a light didn't turn green, I'm getting charged with disobeying a traffic signal. I didn't disobey it, but I didn't wait for it to tell me I'm good to go.
Okay, I'm not aware of a citizen's good to go. This is the busiest the second busiest intersection in Sturgis.
Every night that I go out of work and I go there, I'm sitting there unnecessarily. But like I said,
Now, they did change the law. You can turn left on a red light, right on a red light these days, but you can't just blow through it. I don't make the law.
In the end, this case concludes exactly where the law said it would from the beginning. The judge finds Mr. Sum responsible for disobeying a traffic signal based on his own testimony. The $120 bond is applied to the fine. 2 points go on the driving record, and the case is closed. No jail, no suspension, just consequences. But the broader takeaway matters. This hearing shows how courts balance patience, explanation, and enforcement, and where that patience ends. Laws don't flex based on personal belief, convenience, or frustration with technology. They exist to create consistency, especially in places where safety depends on predictability. Now we want to hear from you. Was the defendant standing on principle or just refusing accountability? Would you have fought this ticket, or paid it, and moved on? If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.